Hearing the appeals Micula and others against Romania.
Well, who's going to tell us what to do next?
My Lady, my Lords, I appear with Mr. Leith for the second to fifth respondents and cross-appellants. Mr. Green and Mr. Warboys appear for the first respondent and cross-appellant. And then we have Mr. O'Donoghue with Mr. Rothschild and Miss Mackenzie for the appellant, Romania, and the cross-respondent. And Mr. Khan appears for the Commission, which, as you know, is intervening in these proceedings. Mr. Green and I have liaised in advance of the hearing so as to ensure that we don't duplicate our submissions. And we've agreed that I will open the cross-appeal on grounds 1 and 2 and ground 4. And Mr. Green will then make supplementary submissions on grounds 1 and 2. He's put his argument in a slightly different way to us, but we reach the same end point. And finally, Mr. Green will address you on ground 3.
I don't think any of that's going to happen.
Well, my lady is referring to the General Court judgment, which you have. So can I start by taking you to the key parts of the General Court judgment and make...
Well, don't you start by taking us to the order?
My lady, yes. So the order is at page 4700 of the electronic numbering, which is in core volume, the core volume, tab 10. 4700. My lady, my lords, this is the order of Mr. Justice Blair, and in dismissing our appeal against this order, against the order of the stay, the Court of Appeal didn't amend the terms of the stay, and you can see from paragraph 3 that the award is stayed pending determination of the proceedings in the GCEU, seeking annulment of the Commission's decision. And so, my lady, the point I'm sure that the court has in mind is that the stay is now lifted because the stay only subsists until the General Court proceedings have been determined, which they now have. Now, there's then a question, of course, as to whether these proceedings have any purpose. And my lady, if the position is that Romania can confirm that it's not going to apply for the stay to be extended or imposed pending any appeal brought by the Commission against this judgment, and of course we don't know if the Commission proposes to appeal or not, if Romania can confirm that, then we agree that the award is now enforceable forthwith and that my clients don't require security. So that's the position.
As at this moment, the award is enforceable.
It is.
Yes, I mean, there is at the moment no order against which to appeal.
There is no order against which to appeal. Now, the concern that we have, of course, is that if the court simply proceeds on that basis, and then we have tomorrow an application brought by Romania before the commercial court for the stay to be imposed again for the same reasons pending any appeal before the CJEU, then we're going to be back at square one, and all of these arguments, very interesting arguments which have been raised, will come to life again, but the only difference will be there'll be yet further delay from my client's perspective.
But the difficulty is, there is at the moment nothing. There is no stay, no security, nothing for us to express our views on the interesting legal arguments deployed at such length in the written submissions. We basically have no jurisdiction. If there were to be an application in the commercial court to vary the stay, well then that could be brought back before us in the usual way, but it might or might not take a long time. Can't express any opinion about that. But the other point is, even then, we have got a decision of the General Court which says that the decision of the Commission was null and void.
Yes.
And unless and until that decision is successfully appealed to the Court of Justice, equally, what's the point in this court expressing an opinion on those very interesting questions of law when we have at the moment a judgment from Luxembourg which tells us what the position is?
May I address the latter point? Because,
Well, you may, but...
but if I could just momentarily address the latter point. It appears to us so that the Commission have a period of 2 months in which to bring any appeal. And of course, my lady's quite right that if the Commission decides not to bring any appeal, then the issues are academic before this court. So we, of course, accept that, and my clients would be delighted in those circumstances because they can then enforce the award, which was promulgated more than 6 years ago.
But you can enforce it now.
They can enforce it now. But, my lord, the practical difficulty, and so we're concerned, so I do, of course, see the points that the court is putting to me, but the practical difficulty is this, that we have an argument, which you've seen in our written case, which is that the English courts have an obligation under the ICSID Convention and the 1966 Act to enforce the award forthwith. And of course, that's reinforced by the General Court judgment. However, we anticipate that it is at least possible, not to say likely, that if we now tomorrow seek to enforce the award in the commercial court and seek measures of execution, that we will be faced with precisely the same argument because the Commission will say, well, we've decided to appeal this judgment, and the Commission will say that whilst there is a pending process before the CJU, which on that hypothesis there would be, the same principle of sincere cooperation issues arise. We think that's what the Commission will say. And so the difficulty with simply drawing up stumps now, in my respectful submission, is that the prejudice which has been accorded to my clients will be reinforced because we'll then be back before the commercial court dealing with precisely the same arguments, and there will then be a significant delay before these points can be ventilated again because, of course, we've got a Court of Appeal judgment against us on the stay.
But I can see the practical arguments,
Yes.
but is there any jurisdiction currently before this? Does this court have any jurisdiction if the order appealed against has flown off?
Well, my lord, there is the court does have jurisdiction to consider matters which raise questions of public interest, even in circumstances where they may be academic. But of course, we say that. It may be that what should happen is that Romania should, I'm anticipating what Romania may or may not do, but it would be interesting to hear what Romania's intention is, because of course none of this arises, and the court's quite right, that if Romania's intention is not to apply to extend the stay, then of course this is all academic, and I don't have to persuade you to do anything at all, but we would say that there's a plain public interest. If Romania don't provide that confirmation, there's a clear public interest in proceeding because these issues don't only engage the private rights of my clients, but the effect of the Court of Appeal judgment is to create an exception generally to the enforceability, the immediate and automatic enforcement of ICSID awards in circumstances where there's a clash with EU law. And the reason that we say that that's a question of public interest is because it touches upon, in a very fundamental way, the United Kingdom's obligations under the ICSID Convention. So if this matter were simply left to lie, what we would have is a Court of Appeal judgment saying that where there is a potential clash or a clash between an ICSID award and EU law, the proper course is to stay enforcement. And we say that's fundamentally wrong as a matter of law, and that the creation of that exception by the Court of Appeal is contrary to the United Kingdom's international law obligations, which of course are obligations shared by the courts.
Yes, we understand all that.
Yes.
We have read your arguments, but the problem that we have is that at this moment, there is no order against which there can be any appeal. That's the problem that we face at this moment. And it's more than academic. It's more than moot. There is nothing.
Lady, may I propose a practical way forward? Because I feel rather disadvantaged by the fact that we've only received this judgment this morning.
I know, and so are we.
And of course, and so it's not so much dealing with the substantive issues in the judgment, but of course, if I had known that this point about whether or not you have jurisdiction to consider the appeal was going to be live, which I must say I had not anticipated that would be a point, and that may be my fault. But if I would have, of course, prepared and properly researched submissions on that point. So if the court is minded not to proceed with the substantive appeal, may I ask that there is a short adjournment whereby we can come back and on each side make submissions on that very point? Because we, for our part, are loath to be in a position where my clients are back to square one after 6.5 years, having to then appeal these points again up to the Supreme Court, and goodness knows when we can get back before you, in circumstances where everything is prepared and the court would be able to decide the point of principle and thus decide whether or not it's even open to Romania to go back and extend the stay. And so plainly pragmatically, that would be the sensible thing to do.
How long would you like?
I think,
How about until 2 o'clock?
well, that would be perfect.
Yep.
I'm very grateful.
I better hear what the other side have got to say. And even possibly what the Commission have got to say. Yep.
This is not satisfactory, to say the least. A few points, if I may. First of all, we did raise this point with the cross-appellates in correspondence 10
Can
days
we
ago.
refer to Romania and the Micula brothers? Can we do that? Because otherwise we'll all get completely at sea as to who is what.
Of course. Romania did raise this point with the Miculas in correspondence about a week ago, because we did apprehend the stay would lapse on the date of judgment, and we have not had a response to that letter. But we are where we are. Second,
Can I just ask, is the money in court?
no, because
No.
the security order was stayed pending.
Right, so it's just, nothing's been paid into
Oh,
court?
Lord, no.
Okay, thank you.
The sequence was the Court of Appeal immediately stayed its order pending permission to appeal, and then the Supreme Court itself stayed it at the end of October of last year. Second point, paragraph 35 of the Statement of Facts and Issues, core volume, tab 5.
Paragraph,
35.
thank you.
It's internal page 4353.
Yes.
The parties GC proceedings, which, by the way, Romania is not a party, which is a point I'll come to, have acknowledged that whatever the outcome, further appeals to the Court of Justice are highly likely, if not inevitable. We'll hopefully hear from Mr. Khan as to the position. But Romania, there's a chicken and egg issue in that Romania is not a party to these appeals, and it's not within Romania's gift whether or not the General Court judgment gets appealed further. But the understanding from the Statement of Facts and Issues, first of all, I think everybody's been proceeding on the basis the Commission decision is valid. It has been annulled this morning, but everyone has also been proceeding the assumption that appeal to the Court of Justice is inevitable. That's a second point. A third point, the Viril Micula and his written case at paragraph 54. And it's over the page on 4495. He says the claimants will not receive a penny of the compensation they awarded by the Arbitral Tribunal in 2013 unless and until the final decision is held to be invalid by the CJEU. So we had apprehended until this morning that everybody in this courtroom was proceeding on the basis of an assumption that the risk of conflict was an ongoing one up to and including the Court of Justice appeal. And quite apart from that, in the context of two levels of appeal at the European level, that would be the working assumption in any event. And we will address the court later on the judgment, but the two grounds on which the decision were annulled are clearly points of law. The first point is on the obligations of pre-accession states as a matter of state aid, and the second point is the concept of advantage interpreted in the context of damages in litigation. So these are clearly two legal points which, in principle, would be admissible as appeals to the Court of Justice. Now, ultimately, there is a fundamental practical problem in that the order before the court today has lapsed. And the court is clearly correct that unless and until something is done, at least on a provisional basis, there is nothing to be appealed. So at a very minimum, and we'll perhaps have to come back at 2 o'clock, but at a very minimum, if the court were to proceed, something at least provisional, bearing in mind the risk of conflict I have adverted to, something provisional would have to be done, because otherwise it is an appeal of nothing.
That's why could you not ask us to extend the stay?
Well, that's exactly what I'm alluding to.
Right. And rather than bouncing back down to the commercial court or anything, I mean, if we're seized with an appeal looking at this order, we could do that.
Everybody's ready to go. A lot of time, money and expense has been expended.
Who would Mr. Demetriou appeal to against our grant of the stay?
Well, my lord, if it were a provisional order wrapped up in the court's final order, that I think is the least worst thing which could be done pro tem.
But the de quo is whether the de quo of the appeal that has been brought to us is whether the English courts have the power to grant a stay.
Well, yes, there is a chicken and egg problem.
Well, if that's not chicken and egg, it may simply be that the final court of appeal, to which this question is before, can't itself exercise the power to grant a stay until it's satisfied itself that it has such a power.
Although there is that sequencing issue, and in my submission, the only practical and lawful way in which that could be dealt with, I take your point about a potential prejudice, is that if there is a temporary extension, and then the final fate of that extension is wrapped up in the court's judgment. I mean, short of doing nothing, it is very difficult to see any other way of proceeding.
Well, counsel might have been waiting on the doors of the RCJ to open this morning, to find a commercial judge to grant them a stay.
Well, yes, we did raise this point with the Miculas, and we have not had a response until this morning. Well, it
is really for you, isn't it, to decide what you want to do?
This was before the annulment. It was then a problem for both parties. I agree at this stage. It's more of an issue for Romania and to some extent the Commission. The final point I would make before 2 p.m. is there are a lot of moving parts in this jigsaw. We have a pending preliminary ruling by the Brussels Court of Appeal to the Court of Justice. The Commission has up to 2 months and 10 days to appeal the General Court judgment. I apprehend they will do this a bit faster, and there may be relief. And there are therefore, in my submission, some potential attractions to seeing how these pieces of the jigsaw play out. Because if, for example, the Commission did not appeal, that would be a fundamental point of departure in this case. Equally, the written submissions in the Brussels Court of Appeal judgment, which will be made by Romania and the Commission, they are due at the end of August, and it will have crystallized at that stage, in writing, exactly what the three parties before the court today are saying on issues such as Article 351. And that is part of my case on the risk of potential conflict. So there are at least two key events that will crystallize in a matter of a couple of months, which may inform how we proceed. So my primary submission, subject to instructions at 2 p.m., is that there is a basis for proceeding, subject to the court's willingness to have a provisional extension. My secondary submission is that if the court ultimately feels it does not have jurisdiction, there may be a case for adjourning to see whether these two events, which are critical, have crystallized to a point where the conflict either has disappeared or certainly is staked out in much clearer terms.
Just exploring the procedural position while we're all here. If you ask us for an extension of the stay, and assuming we have jurisdiction to entertain such an application, am I right in thinking that all the legal arguments would be the same? Because you would be saying to us, both that we have jurisdiction, I mean, we need to just check on that, but assuming that we have jurisdiction to deal with interlocutory matters in relation to an appeal, you would be saying, and grant a stay for all the legal reasons that, in effect, are live in the appeal as it stood yesterday. Is that right?
My Lord, yes. And as I indicated, we had been proceeding on the basis of an assumption that the ultimate conflict would be the Court of Justice judgment. I thought that was common ground based on the statement of facts and issues in Mr. Green's written case. I detect that it may not be in the light of the judgment, but fundamentally, nothing has changed in terms of the risk of conflict and the types of arguments we would wish to raise. I mean, we'll hear from Mr. Khan, subject to the court's permission, but the General Court has not decided 6 of the grounds of appeal, and if the Commission appeal is successful, there will have to be a decision on those grounds of appeal. A number of those grounds of appeal, in any event, in our submission, are wrapped up in the preliminary ruling from the court, from the Brussels Court of Appeal. So all the essential elements going to conflict, and therefore the question of stay, remain in place and haven't fundamentally changed. I mean, what has happened is the decision has been annulled. I apprehend there will likely be an appeal, but that is essentially an interim step in a 2-tier appellate process. So in our submission, from the perspective of conflict, the situation has not fundamentally changed. There are some wrinkles around the side. I don't wish to trivialize the question of jurisdiction, but if I am right on the question of conflict, and there is an obligation to stay based on sincere cooperation, that would apply with equal force to a pending or putative appeal to the Court of Justice. I perfectly take on board there has to be some order in the interim seizing you, but in my submission that is an important point, but the bigger picture is the question of the conflict, which is a central issue in these appeals.
We have no problem understanding what the big picture is. The question is whether it is possible or appropriate for us to address the bigger picture at the moment. Possibly better hear from Mr. Khan.
My lady, my lords, thank you. The situation is indeed very unfortunate. It's one that we had hoped to avoid. It's not in any of the bundles, but I hope the court received the letter that we sent to the General Court, a copy of which we sent to your lordships, asking the General Court to change the date of its judgment. Unfortunately, that's a plea which fell on deaf ears, and so we have this particularly unhappy conjuncture of events. It may be that I'm at fault for not having suggested that the order of Mr. Justice Blair be in terms not just until the judgment of the General Court, but until the expiry of any period for an appeal. But that wouldn't have been a problem had there not been the judgment of the General Court arriving at the same moment as day one of this hearing. It's common ground that the annulment is a clear annulment, and it has no suspensive effect unless a suspension is sought from the Court of Justice on an appeal. Now there, I'm afraid, my lords, that I have two practical problems to confront. First of all, although I think the second to fifth claimants sum the position up fairly in their written case, where in footnote 2 on page 4537 of the core bundle, it said that they proceed on the basis that the decision is assumed to be valid, and it is common ground that further appeals are practically certain. I can't give any further assurance beyond that pragmatic statement by the second to fifth claimants that appeals are practically certain. That is because a decision by the Commission to appeal requires a Commission decision. That, I'm afraid, involves a certain amount of internal paperwork and bureaucracy, the duration of which is to be measured in weeks rather than days. The second problem I have is that even if the Commission decided to appeal, and if the Commission wanted to seek the suspension of the operation of the Court of Justice's judgment pending the outcome of the appeal, that's possible. That's Article 160 of the Court of Justice's Rules of Procedure. But Article 160, paragraph 1, says that an application to suspend the operation of any measure adopted by an institution, that includes the Court of Justice in the form of the General Court or the Court of Justice itself, shall be admissible only if the applicant has challenged that measure in an action before the court. So, unlike the position that would prevail here, where a party could seek relief on an interim basis straight away, it won't be possible for the Commission to seek interim relief against the General Court's judgment unless and until it has lodged an appeal against the General Court's judgment. So first of all, a Commission decision authorising the Commission's lawyers to lodge an appeal is necessary. Then the appeal has to be written, lodged at the court, and at the very earliest, simultaneously with the lodging of the appeal, an application for interim relief from the Court of Justice. So although I'm grateful for the court's readiness to rise until 2 p.m., I fear that by 2 p.m. I can't offer any greater clarity than at present. Then, as my learned friend Mr. O'Donoghue has mentioned, the jigsaw is complicated by the fact that there are proceedings in other member states, including the reference from the Brussels Court of Appeal. There are also national proceedings in Luxembourg and in Sweden and in Romania, of course, and we don't know what, in the light of today's judgment from the General Court, the Miculas might be doing with respect to those other national proceedings. All of that indeed augurs in favour of the Commission reaching a decision on an appeal as soon as possible, and although I think in the circumstances a decision will have to be taken as soon as possible, I'm afraid it won't be by 2 p.m. today. My lady, my lords, I think that is all I can say at the moment.
Thank you very much, Mr. Khan.
Thank you.
Well, yes, we'd better hear from you, Mr. Green.
Eventually, milady. Milady, it's obviously a distinct situation from that where the parties have reached settlement and the court nonetheless hears the appeal. It's a distinct situation because of the lack of jurisdiction point which your ladyship's raised. One way of dealing with it on a practical level is for my learned friend, Mr. O'Donoghue, to seek an order this morning before 2 o'clock from the High Court for a stay, and for this court to entertain a double jump appeal of that order, because there's no prospect of not obtaining a stay on the basis that there's presently a binding Court of Appeal judgment in my learned friend's favour So it's effectively binding on the High Court judge who's approached this morning in whatever, room 98 or whatever urgent route we can find. It won't be, it'll be in the commercial court actually.
So I don't think it's going to be room 98.
No, it won't be room 98. But the short point is...
I mean, if I may, I do question whether that's necessary.
Well,
I don't
forgive
see-
me.
Yeah, forgive me. Yeah.
I don't think we should express any opinion on this
No, all right.
without having discussed it.
But Milady, there's clearly room for different views about it. And I've
Yes.
just, in the event that the point is a jurisdictional one, of actually having an order which puts to rest any difference of views about it, that's one practical approach which could be taken. And one which would address the vice of this being almost the only day upon which the decision of the General Court could have been given to achieve this difficulty for this court.
Well, who knows?
There we are.
And the stay would have to be sought by Romania in order to preserve the position, but in a situation where the decision they rely on has been annulled.
My lord, that's right. And the premise of that stay is the same premise of the stay canvassed with us before these proceedings, before this appeal a week ago. What Romania wrote about a week ago was the possibility of a further stay in the event that they lost in the GCEU. And so your lordship's right that the Court of Appeal decision doesn't deal with precisely the same point, because it's the anticipated appeal pro tem. So that there would be theoretical room for a High Court judge to say no on that, but there ought to be ways for the parties to facilitate an order being made that could be appealed to this court.
Well, I'm just sort of thinking about it, because you wouldn't, I imagine, it'd be difficult for you to consent to the stay and then appeal against it.
There are ways around that.
Yes, your lordship's right that a consent order would not work and would not be helpful, but I said it carefully because it's obviously got to be finessed quite carefully.
Yes, and you would take care to finesse it.
Whilst trying to help everyone out, we don't create a different problem.
Yeah.
But there is one further point which my learned friend rightly draws my attention to, which is, of course, we're also appealing the order on costs. And that does give this court jurisdiction to determine what an appropriate costs order would be. So there is that basis as well, to which the court may wish to give consideration in parallel to the parties' consideration between now and 2 o'clock. So, Lady, those practical suggestions and nothing further to add unless I can help further.
Well, does it mean that it makes sense for us to adjourn until 2 o'clock, or does it mean that it makes sense for us to go outside and have a little chat?
Well, I wonder if a little chat might, because it's quite a lot of pressure on the timetable anyway, and it might be helpful to have a little chat, even if only to come back and say 2 o'clock.
Right. We will go and have a little chat. Well, we've had our little chat, and the current position is that we will adjourn until 2 o'clock, so as that gives you more time to work out what your position or the position is, because obviously things may happen between now and 2 o'clock, we know not. We are not currently minded to grant a stay ourselves for the reasons that we have explained, and therefore there is a problem about whether there is anything against which to appeal. Were the situation to change, and one could foresee that it might or might not change within the next 2 months, depending upon what the Commission decides to do, well then it would be possible to relist this case next term, We have ascertained that. We have made inquiries of the registrar, and that would be possible. And we think very probably before the same constitution, which would save a certain amount of time from our point of view and possibly even from yours. So is that clear enough until 2 o'clock?
It's very clear and we're very grateful.
Can I just raise one further point, if I may? Romania, of course, is a state, and for me to get instructions to apply to the commercial court for a stay in the next 120 minutes will be a difficult thing.
Yes.
We're not
No,
quite in the
yes.
Commission's boat, but we are a state, and there is that.
Well, we understand
complication.
that, and it may be that nothing has happened by 2 o'clock, and that's very possible. Mr. Dimitriou may have some arguments about why we should go ahead in any event, and we shall wait to hear those. But we understand the situation in which you find yourself. But if we've made ourselves plain enough for the time being, we will look forward to hearing from you again. 2 o'clock.